I think we're now ready to resume. Mr. Crowe.
Thank you, my lord. I was about to move on to ground 2 of the appeal. Ground 2 proceeds on the assumed basis that you regard OBG and Allen as authority for the proposition that the dealing requirement is a requirement in relation to the tort generally, in all cases. The purpose of ground 2 is to try persuading you to leave OBG and Allen entirely undisturbed, other than in relation to that issue. So we would not seek to persuade you to alter any parts of the instrumentality, actionability, excuse me, relevant wrongfulness or intention elements, but simply to remove the dealing requirement as a general requirement in all cases. Much of the spadework in relation to this a line of argument has already been presented in the course of what we have covered before the short adjournment. But the one thing I just wanted to emphasize essentially was this. In the factual situations which most often arise, where there has been dealing or there are prospects of dealing, if the claim fails the dealing requirement, fails to satisfy that requirement, that is simply a reflection of the fact that the claim fails to satisfy the instrumentality requirement. Because if there is a dealing relationship between the third party and the claimant, and the dealing requirement isn't satisfied, excuse me, that is simply another way of saying that the claimant has failed to demonstrate that he has been struck at by the defendant taking unlawful action against the third party, which is the cause of the loss to the claimant. Whereas, in a public authority case such as this, and Lunro and Fayed, if the dealing requirement is not satisfied, that is a reflection of the fact that it represents an arbitrary and inflexible rule which says, first of all, actually in no public authority cases can a claim for unlawful means, for the tort of unlawful means, ever succeed. Because in public authority cases, there is never going to be a dealing relationship between the Secretary of State who is misled, or the EPO or the English courts who are misled, and the person who suffers the loss. So to impose the dealing requirement in the generality of cases, including public authority cases, you are simply eliminating in limine a category of potential claimant. And the second principled objection to that is that you are cutting out that category of claim by reference to the relationship between the third party and the claimant. The dealing requirement describes the relationship between the third party and the claimant. We submit, and this is a point that we'll come to when we look at the article by Lord Sales and Professor Davis, and we, with respect, strongly agree with this, that the relevant relationship in any wrongdoing case is the relationship between the wrongdoer and the victim. Obviously, in an unlawful means tort case, the wrongdoer is the defendant and the victim is the claimant. So what you should be looking at is what defines that relationship. So if you excise all dealing cases, if you excise all cases that fail to satisfy the dealing requirement, you are therefore eliminating a category of claim not by reference to the relationship between the defendant wrongdoer and the victim, but by reference to the relationship between the third party and the victim. And that solution would have nothing to do with the unlawfulness perpetrated by the defendant. It would have nothing to do with the intention of the defendant to cause the claimant harm. It would have nothing to do with the question whether harm was caused. As we say, it would solely be driven by what we submit would be an arbitrary rule applicable in all public authority cases by reference to an irrelevant consideration. So that essentially is the core objection to having this dealing requirement apply outside cases which are themselves dealing cases. The other point, which in a sense I don't have to make, but can be made, is simply this, that even in relation to commercial dealing cases, not every dealing relationship will necessarily be direct between the third party against whom an unlawful act is perpetrated by the defendant and the claimant victim. If there are intermediary actors in the commercial dealing chain, then the other incidental effect of introducing the dealing requirement as a uniform rule in all cases is that any element of intermediary dealing, and if there are any fourth parties in the chain, then those claims would be eliminated as well as a matter of principle. Now, as we say, as a matter of principle, we suggest that that is simply the wrong outcome. If you do interpret OBG and Allen as producing that outcome, as we say, as we've already said in relation to ground one, we would submit that the House of Lords in that case would have been overreaching itself, because it would have been expressing a rule in relation to matters not in front of it. It would have been doing so without any need to achieve that outcome in that particular case. And essentially, although we can all agree, in a sense, in the abstract, that economic torts are things that need to be kept within proper bounds, if the function of economic torts is to protect economic interests against inappropriate conduct, against unlawful conduct, then the three-party unlawful means tort shorn of the dealing requirement achieves that objective. Introducing the dealing requirement doesn't introduce any sort of principled narrowing of the application of the tort. It simply introduces a sort of fact-specific arbitrary restriction on the application of the tort. And it does so, as we would submit, by reference to an irrelevant, or at least a far less relevant consideration, namely the relationship between the third party and the claimant. My Lord Hamlin.
Yes, Mr. Crowe, if you take out the dealing requirement, but otherwise the law is as stated in OBG, do you accept that potential claimants in a case such as this include all those identified by Mr. Justice Roth, paragraph 43 of his judgment?
No, we don't actually, and I'm glad you raised that question, my Lord. I wasn't instructed at the time, so but I understand that the concession Mr. Justice Roth refers to was indeed made in orally in the heat of debate. It was in fact retracted in the skeleton argument we put forward in the Court of Appeal. That's not in the bundle, but in paragraphs, I think 31 and 32, I've got a note somewhere, 32.7 of our skeleton argument, we can provide that to you if you wish. But the rather just the historic point, whether we did or didn't retract it, is not a concession with respect that should be made. It was made in error because the defendant simply would not know, as at the date when the deceit was perpetrated, in 2001, I think. Sorry, just a point of detail, the legitimate, so to speak, patent ran until 2003. So the deceit is perpetrated in 2001. As at the date of that deceit, Servier isn't going to know, if any, or if so, which generic manufacturers might wish to enter the market in and after 2003. Nor would they know whether any medical insurers would or would not be in business at that point. So with respect, it would be effectively impossible for a generic manufacturer to establish the necessary intention to harm. And for that reason, we would submit that concession, having been made orally, was, with respect to the counsel then instructed, made in error, and as I say, corrected in the court below.
What about other health authorities?
If one is talking about, effectively the purchaser in the United Kingdom, that is essentially my client. If one is talking about health authorities in other jurisdictions, one would simply have to look and see what the structure is there. I mean, the reason why the claim works, or we say for these purposes, it has a reasonable prospect of succeeding, is that essentially my clients are the purchaser in England and Wales. And so that is why, and in that paragraph that I read from the particulars of claim, we submit that the intention on the part of Servier to make the gain out of this deceitful patent application necessarily requires the loss to my client in this jurisdiction. It is the necessary means to that end. And that is the intention. It's a rigorous intention element. If in other jurisdictions there may be other purchasers, it would simply be a question of fact as to whether or not the intention element could be established.
Could I just pick you up on that a little bit more, because that may be the position in this case, but that's because there was, as you explained a moment ago, a master patent which protected the market for at least a year or two after the grant of this a particular polymorph patent. But that wouldn't necessarily be so. And in the general case, one might apply for and prosecute a patent which, as I understand it on this assumption, would have been pursued by the applicant deceitfully, knowing that the patent was invalid. But the impact of that patent on the market might be perfectly plain to the patentee and indeed deter competitors. Why wouldn't they have a claim?
Well, my lord, part of the answer to any of these hypotheticals is simply to say simply to respond. It's difficult to know what exploring these really demonstrates. If you have a tort that is defined by reference to a rationale of providing a remedy where there has been unlawful behavior intending to cause loss to an identified claimant and causing that loss through unlawful conduct, then the question whether it does or doesn't work in any particular hypothetical factual situation doesn't really, with respect, assist the court in deciding whether or not that is the right structure for the tort. Millennial friends will say, well, it might work in this case and it might work in that other case, and therefore try constructing a sort of floodgates argument. But with respect, one simply has to address the principles question. What are you trying to achieve with this tort? And what are the appropriate control mechanisms? And our very short answers to that are that what you're trying to achieve is to provide a remedy where there has been unlawful conduct, which is intended to produce a gain which necessarily causes a loss to an identified claimant. And if that factual situation can be established in any given case, well, yes, the claim should succeed. With respect, hypothesizing, and frankly, we're as guilty of it as any, hypothesizing other factual situations that might arise and might or might not succeed in our submission doesn't necessarily advance the argument of principle as to whether or not this is the right tool for controlling the scope of the tort. And we, for the reasons I've already given, we say that the dealing requirement is simply not the right tool.
May I ask another question in this context? If you're wrong about the dealing requirement, and one's considering whether or not, in this particular context, the scope of the tort should be expanded to cover this sort of situation, the legislature in this jurisdiction, and indeed in the European system, have chosen not to provide any concept of a fraud on the Patent Office. And the question might arise as to whether or not, well, first of all, the EPO might be rather surprised to know it had a potential cause of action against an applicant for a patent which the applicant knew or ought to have known was invalid. But be that as it may, might it not be said that this would have quite a substantial impact upon the whole patenting process and result in us taking a course which the legislature here has chosen not to adopt, namely to have some sort of concept of fraud on the Patent Office?
Could I offer two answers to that, one sort of fact specific to this case and one of general principle? The first is that the case has been argued, for good or ill, on the assumed basis there was a deceit. The question whether or not the Patent Office would have a cause of action or not is not part of the framework for the issues in this appeal from, I think it's paragraph 21 or 22 or so of the first instance judgment. The case has proceeded on the assumed basis that the deceit element, the unlawfulness element, is established. So that isn't on the table.
Yeah.
That's just, in a sense, a description to you, my lord, of what is the issue that falls to be decided.
Yeah.
The more general answer to your point is simply this, that with respect, it is wrong, and this is a point that my learned friend includes in her case. It is, with the greatest respect, wrong to try arguing for an outcome as to the general contours of a tort by reference to the specific facts of the case in hand. The common law devises torts by reference to questions of principle. And with respect, it would not be an appropriate way forward to say, well, we've got to keep the dealing requirement for all cases, because in this patent case, it might produce a result that Parliament hasn't itself delivered. And the other part of the answer on the question of principle is that simply because Parliament hasn't provided an express remedy in this situation does not demonstrate that the common law must not do so itself, even if you are only looking at this from a sort of patent perspective. The fact that there happens not to be any form of express legislative remedy does not, in our submission, lead to the conclusion that the common law mustn't go there. The common law identifies rationales for causes of action and appropriate restrictions by reference to questions of principle as to their scope of application. And if through the control mechanisms that have been identified in ABG and Allen, instrumentality, actionability, and intention, one is satisfied that that is an appropriate package to control the tort. If one has cases of loss like this, then in our submission, the common law should be comfortable letting it go forward. I mean, just to look at it another way around, if the case of Lunro and Fayed had gone to trial, the Fayeds could not have defended that by saying, oh, well, you can't get us for the unlawful means tort because that might mean that a patent claim, a claim against a fraudulent patent applicant might be allowed. That kind of approach to the development of the common law, it simply doesn't work. Obviously, if legislation is positively inconsistent with a particular outcome, then the common law won't go there. I entirely agree. I entirely accept that, but that isn't the argument. The argument here is simply that there isn't a legislative remedy, and from that it is being argued that the common law shouldn't or mustn't produce one, and that, in our submission, is false logic.
Thank you.
I was, at this point, just going to deal very briefly with some of the other points. That was, in fact, I'm grateful that was going to be one of the points, because I just wanted to mention a couple of the arguments against us in relation to this. Some I've already dealt with, and I can dispose of very shortly. The first and main point, in a sense, from my learned friend is to say that excising the dealing requirement would be wrong, simply because the dealing requirement reflects the rationale of the rule. And our answer to that you've already got, and in a sense I gave the answer to my Lord Briggs' question. The fact that the unlawful means tort has arisen largely in cases involving labour disputes or trading disputes is simply a factual comment on the fact that most people lose money, if they lose money, in relation to trading. But it doesn't define the tort. It's simply descriptive of the circumstances in which the tort happens to be invoked most often. It is not normative as to the substantive legal content of the tort. So in our submission, to suggest that the dealing requirement is the rationale for the tort is simply wrong. Second point my learned friend runs with that I just wanted to answer is this. There's a thread through my learned friend's case saying that our suggestion that the dealing requirement can be dispensed with and that it is enough if the claimant has an interest in the actions of the third party. She says that that is too weak a test. That argument from my learned friend with respect is based on a misunderstanding of the tort as we understand it to be described by Lord Hoffman in OBG. Can I just take you back to our case at page 54 of the bundle, which encapsulates our summary of the elements in the tort. And paragraph 9(1) identifies the instrumentality requirement, and we say the defendant must have engaged in conduct that harms the claimant indirectly by interfering with the actions of a third party in which actions the claimant has an interest. Thus, the third party's conduct forms a necessary link in the causal chain between the defendant's conduct and the harm suffered by the claimant. Now, when we use that expression, actions of a third party in which actions the claimant has an interest, we're not saying that the words actions in which actions the claimant has an interest, that is not part of the substantive legal element of the claim. The substantive legal elements are the instrumentality. Does the defendant strike at the claimant by using unlawful means against the defendant? And do the defendant's actions harm the claimant? If they do harm the claimant, the instrumentality requirement is met. And in a sense, the words actions in which the claimant has an interest simply describe that consequence. They are not they're not some sort of freestanding test that we are suggesting as a substitute for the dealing requirement. They are simply descriptive of circumstances in which the instrumentality and relevant wrongfulness requirements have been met. And as it happens, I mean, my learned friend suggests that they are inadequate. They have a respectable heritage in the sense that they are the words used by Lord Hoffman himself in paragraph 47A of OBG and Allen. That is how he describes the nature of the interference. And the same words were adopted by Lady Justice Arden as she was in the case of merits. I won't take you to the reference, but it's quoted in an article by Hazel Carty, which is in the bundle, and I'll just give you the that's on page 1874, and it's also adopted in Grant and Mumford on civil fraud, which is in the bundle at page 2035. So the expression has a respectable heritage, if I may say so, coming as it does from OBG and Allen itself. As I say, we're not putting it forward as the legal test for identifying whether there has been an unlawful means tort committed. The claimant will, as I say, the words are simply descriptive of the situation in which the tort will have succeeded because the instrumentality requirement and the need for causative loss will have been satisfied. If those elements are satisfied, by definition, the claimant will have had an interest in the actions of the third party which have caused him the loss. That's all it's doing. So my learned friend, with respect, is tilting at windmills on that particular point. And the other very closely related point, my learned friend's written case repeatedly refers to what is characterized as our weak instrumentality argument. Now, I don't want to go back to it, but when you reread paragraphs 53 to 59 of my learned friend's case, you will see that the whole of that discussion ignores the requirement for intention. And it is, with respect, a flawed line of argument to suggest that our structure of the tort depends entirely on instrumentality. It doesn't. Our structure of the tort under this heading of the argument is OBG and Allen, shorn simply of the dealing requirement. So we're not suggesting any different instrumentality requirement from that established in OBG and Allen. But it's not just instrumentality. The claimant has got to satisfy an intention, proving an intention to cause loss to that plaintiff by the unlawful action directed against the third party, causing conduct which produces the loss to the claimant. So again, as I say, with respect to my learned friend's line of argument, simply doesn't address the case that is being put. There's also, just very briefly to mention it, there is also a section in my learned friend's case where she suggests that our solution would ride roughshod over related torts. And some references is made to malicious falsehood and malicious prosecution. I'll respond in more detail when we hear those arguments being developed orally. But the short points are simply these up front. The first is that it is absolutely trite that the common law has conceived torts which, to some extent at least, overlap. And indeed, the cases that my learned friend relies on herself and the commentary she relies on demonstrate that. Malicious falsehood overlaps to some extent with defamation. Malicious prosecution may or may not also involve other torts. And one of the interesting things that one sees, one of my learned friend's particular points is that the court should be very reluctant to develop the common law as producing remedies in relation to misuse of the judicial process. So alluding to the obtaining of injunctions in this case by Servier. But we have two cases in the authorities bundle which demonstrate exactly the counterpoint to that, which is that in an appropriate case, the court absolutely does, the common law absolutely does allow a tort claim to be brought in relation to misuse of the court process. Abliazov number 14 is a case of a conspiracy brought against a litigant and the litigant's son-in-law for effectively thwarting a worldwide freezing order. I won't take you to it, but it's if you look, the decision starts at page 519 of the bundle. The relevant paragraphs that I would just draw your attention to, particular paragraph 4, 16, and 24. And there's another case in the bundle where a claim was brought, again, in relation to litigation, claiming essentially a conspiracy to abuse the process of the court by producing false documents. Now, one might well again say, well, you know, the contempt of court already covers that. Why do you need that? But the common law has no hesitation in crafting and allowing the development of remedies in appropriate circumstances, even though it may well overlap with other regimes which also cover aspects of the same thing. The conspiracy to abuse the process of the court is the case of Servier Overseas and Koros. And again, I won't take you to it, but the report starts at page 1545. And I particularly invite your attention to pages 1553 to 1554. The final point, just to respond preemptively to my learned friend, is this, that one of the last points in response to our invitation to you to excise the dealing requirement from the OBG model of the tort. My learned friend's argument is that the decision in OBG and Allen produced, in her words, much needed clarity to the law. And on that basis, she invites you not to disturb it. There are a number of responses to that that we would urge on you. The first is that, yes, OBG and Allen did provide some clarity in the law, much welcome in particular in conceptually differentiating between procuring a breach of contract on the one hand and the unlawful means tort on the other. But as you may notice, if you cast your eye over the academic commentary since OBG and Allen, it only has produced clarity up to a point, even on its own terms, because there remains this debate between Lord Hoffman and Lord Nichols about what is the appropriate test of unlawfulness in this context. And since OBG and Allen was decided, that particular debate has acquired a sort of added piquancy, because, as you will know, for the purposes of the tort of conspiracy, unlawful means conspiracy, the subsequent decision of this court in Total Network has come up with a different test of unlawfulness in relation to that tort. Essentially, for the purposes of unlawful means conspiracy, this court has accepted Lord Nichols' approach, that criminal conduct and not just actionable private law torts satisfy the test for unlawful means in the context of that tort. Now, that doesn't prove that Lord Nichols' approach to the unlawful means tort should now be preferred, but it certainly erodes the clarity of the law that was to some extent established in OBG and Allen. And the other point in response to my learned friend's urging in relation to this particular issue is that, while it is, as I say, true to say that OBG and Allen did introduce some clarity in relation to this tort, the proposal we are making and ground 2 of our appeal does not involve creating any uncertainty in the law. It's not stirring up the mud again. All we are suggesting to the court in relation to ground 2 is clinically to excise the requirement for the dealing requirement, if you reach the conclusion that that dealing requirement does form part of the ratio of OBG and Allen. Acceding to that request doesn't create uncertainty. Indeed, it enhances certainty insofar as one can read OBG and Allen in different ways on that point. So the acceding to my request in relation to ground 2 doesn't in any way undermine the clarity of the law. It simply delivers clarity in relation to this particular issue differently, as it happens, from OBG and Allen. But if your lordships accept our principled argument that you should come to a different conclusion, well, you should embrace it with respect. So that was just a very quick counter through, and I thought it helpful just before my learned friend addresses you, just to give some preemptive responses to some of the points in the respondent's case. The other thing I just wanted to touch on very briefly is this. I mentioned in response to my Lord Kitchen's question that we ourselves have been as guilty as others of coming up with hypothetical cases. You may have seen quite a lot about pizza deliveries, and if you have read Lord Hoffman's article, you get ice cream salesmen too. It is always possible to come up with hypothetical situations to try testing what might be the outcome in any given situation. I'll obviously hear how my learned friend deals with these points orally, but for the purposes of opening, all I would say is this, that whereas we have come up with a number of hypothetical situations which we say would call for a remedy, being realistic, I would have to accept that if we have not persuaded you that the dealing requirement should be excised by reference to the merits of this case, we're probably not going to persuade you to excise the dealing requirement by reference to the perceived merits of some hypothetical case that isn't in front of you. We say that Lunro and Fayed, and this case, provide very compelling illustrations of why the imposition of a dealing requirement as a blanket requirement in all cases of the unlawful means taught, irrespective of the facts, produces arbitrary and unjust results. We have tried, as I say, to try and fortify that point by postulating other hypothetical situations. And my learned friend has dealt with some of those by tweaking the facts or presenting partial alternative remedies in other tort law, from other tort remedies. But as I say, I slightly doubt your lordship is going to be deciding this case by reference to hypotheticals. We would submit that this case, on its merits, cries out for a common law remedy. As I say, I wasn't unless my learned friend is going to develop the arguments orally in relation to our hypotheticals. I'm not going to spend any real time on them. Just before leaving it, though, I mean, our first one was the hypothesis that somebody maliciously, or for perhaps good environmental reasons, whichever, causes Heathrow Airport to be closed down. We pointed out that if the bomb hoax is reported to British Transport Police and British Transport Police shut Heathrow Airport down, instruct air traffic control to stop or divert all flights and tell British Airways they're not allowed to take off, that would be a public authority, British Transport Police, being misled, that public authority having no dealing relationship with British Airways. British Airways would have no cause of action if the dealing requirement was a necessary part of the tort. Whereas if the bomb hoax was communicated to Heathrow Airport Holdings, which British Airways does have commercial relationship with, then the dealing requirement would be satisfied. Now, instead of actually addressing that dilemma, my learned friend's answer to it is simply to change the facts and say, well, if British Transport Police then rang Heathrow Airport Authority and told them about the bomb hoax, then the public authority would just be the the means through which the airport authority would be misled. But I'm not quite sure whether this debate advances matters. All we would observe is that my learned friend hasn't come up with a principled answer, and the response given, as I say, it simply tweaks the facts. If you take the facts as we hypothesize them, which is that the public authority takes the decision in the public interest to shut the airport, the dealing requirement can't be satisfied. Whereas if the bomb hoax is communicated to the airport authority, which British Airways does have commercial relations, then the dealing requirement could be satisfied. And in our submission, that kind of arbitrary difference of outcome, depending on to whom the hoax is communicated, is just not the sort of principled way in which the common law ought to proceed. Finally, then, in relation to ground 2, I just wanted to say a couple of words about the law on overturning previous authority. Your lordships will be familiar with the practice direction. We've got that, the 1966 practice direction, practice statement, which is in the bundle at page 1276. And I'm sure you're familiar with it. The Lord Chancellor, having recited that precedent is an indispensable foundation upon which to decide what is the law and its application, it provides at least some degree of certainty. Their lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law. They propose, therefore, to modify their present practice, and while treating former decisions of this House as normally binding, to depart from a previous decision when it appears right to do so. In this connection, they will bear in mind the danger of, and then there are two specific portions expressed, neither of which applies in this case. And the two are retrospectively disturbing the basis on which contract settlements of property and fiscal arrangements have been entered into, and the special need for certainty as to the criminal law. So the test is when it appears right to do so. Yes, of course, it is a power, discretion, matter of judgment to be exercised with caution. But if you are satisfied that the dealing requirement doesn't have a principled basis, is inconsistent with earlier House of Lords authority, which OBG and Allen did not overturn, and you are satisfied that it would, the application of that requirement to the facts of this case would produce injustice and would restrict the development of the law in the sense that it imposes an arbitrary and inflexible rule in all cases, then in our submission, the requirements expected in the practice statement are amply satisfied. So, as I say, just in conclusion on ground 2, our ambition is modest in the sense that we would leave the edifice of OBG and Allen entirely intact, save for this one element, which is not a necessary element to the outcome in OBG and Allen, and would, in our submission, be inconsistent with earlier case law and produce injustice in this one. Ground 3. Ground 3 invites the court to consider whether or not to adopt a refashioned model of the tort based with respect on articles written by my Lord Sales with Daniel Stillitz and by my Lord Sales with Professor Davis. We confess to some diffidence in advancing this line of argument for two reasons. One is that I'm addressing one of the authors, and the other is that we don't need to win on this in order to succeed on the appeal. We are advancing this because obviously this particular appeal raises this particular solution as a possibility, but our understanding, we'll come to this in a moment, our understanding is that the dealing requirement has no place in the refashioned model of the tort proposed, if I can, with no disrespect, call it the Sales-Davis model, we apprehend that there is no place for the dealing requirement in that model. And for that reason, we would embrace this as a solution. But as I say, we would not wish the court to understand that we have this ambition for its own sake. We're not seeking to achieve anything other than to remove the dealing requirement. If we can do it by this route, amen. But that is, in a sense, the incidental benefit of its adoption for our purposes. One particular aspect of the proposed refashioned tort is that it would essentially embrace Lord Nichols' approach to unlawfulness rather than Lord Hoffman's. In that context and for that reason, it is perhaps helpful to look at a little bit of case law both before and after OBG and Allen that we haven't yet looked at. For this reason, that if we look at Rooks and Barnard, which you may recall is mentioned in OBG and Allen as embodying an aspect of the tort, the unlawful means tort. If we look at Rooks and Barnard, we will see there that the House of Lords did consider, in the context of intimidation, that criminal activity, rather than merely actionable torts, is perfectly capable of constituting the relevant unlawfulness in the context of intimidation. And if we look at case law since OBG and Allen, total network, the revenue and total network, as I say, we will again see that a broader concept of unlawfulness has been embraced in relation to the unlawful means conspiracy tort. I just wanted to spend a couple of minutes looking at those and then take you to the article itself. But as I say, the article speaks for itself, and there's not, I think, a great deal I can do to improve on it. There's probably quite a lot I can do to do violence to it by oversimplifying and summarizing it. So I wasn't going to spend too long trying to construct the argument in favour of this, because, as I say, it's not our purpose to construct that argument for its own sake. The benefits that we seek to derive from it are incidental, because we see the elimination of the dealing requirement as being part of the package, and I'll explain that in a moment. But just in order to put the proposal in context, can we just look very briefly at Rooks and Barnard, which is at page 1385. And this was a case involving a BOAC employee who resigned from his union. The union wanted to maintain a closed shop. The union representatives threatened a strike, and BOAC suspended and then dismissed the employee. And so the employee sued the union representatives for the tort of intimidation based on their having used threats of breach of contract against BOAC in order to induce it to do something which, as between BOAC and the employee, BOAC was entitled to do, which is to serve notice terminating his employment. And you may recall we paused on it very briefly when looking at paragraph 7 of OBG and Allen. Lord Hoffman treated Rooks and Barnard as, in his words, one variant of causing loss by unlawful means. So Rooks and Barnard should properly be regarded as being in the same stable as the unlawful means tort, and for that reason relevant in the mix of looking at what the test of unlawfulness requires. Essentially, the question in Rooks and Barnard specifically was whether threats by the union of breaches of contract could constitute unlawful means. The answer that the Lords gave was yes. The terms in which they expressed that answer make it perfectly clear that they regarded criminal acts as being sufficient for these purposes as well. And we just look very briefly at passages in the speeches of four of their lordships, starting with Lord Reid at page 1424. And if we just pick it up 7 lines from the bottom of page 1424, with a line beginning by unlawful means. And Lord Reid continues, so long as the defendant only threatens to do what he has a legal right to do, he is on safe ground. At least if there is no conspiracy, he would not be liable to anyone for doing the act, whatever his motive might be, and it would be absurd to make him liable for threatening to do it, but not for doing it. But I agree with Lord Herschel, Allen and Flood that there is a chasm between doing what you have a legal right to do and doing what you have no legal right to do. And there seems to me to be the same chasm between threatening to do what you have no legal right to do and threatening to do what you have, threatening to do what you have a legal right to do and threatening to do what you have no legal right to do. And that essentially, I think, is exactly the wording Lord Nichols adopts in OBG and Allen to encapsulate his, what has been called, broader unlawfulness test. And it is clearly broad enough to capture not just actionable torts, but criminal activity and breach of contract. And one sees the same from Lord Evershed at page 1438. And he poses the issue a third of the way down the page. He poses the issue, assuming, therefore, 1, that each defendant did so threaten and effectively threaten; 2, that because of this special term deemed to be incorporated in each union man's service contract, the threat was of unlawful action on the part of all these men in the sense of constituting a threat to commit a breach of their service contracts; and 3, that the threats were directed at the appellant, being designed to cause an end to his employment with BOAC. Question: can the appellant successfully sue the defendants for damage he thereby suffered? This single problem has inevitably been dissected into 3 separate questions. And it's the second question that matters for us. The first is whether the tort of intimidation is known to English law, and then a few lines below that, 2. If so, are the wrongful acts which the person or persons threatened by way of intimidation do confined to acts in themselves criminal or tortious, or do they extend to other so-called wrongful acts, including particularly breaches of contract? So the very way his lordship poses the question accepts that criminal acts would be sufficiently wrongful for the purposes of the tort of intimidation. If one then whips on to page 1441, one gets the same point. About 2/3 of the way down the page, there's a line beginning, so far I have agreed with the Court of Appeal, but I respectfully differ from the Court of Appeal in thinking that the wrong of intimidation must stop short so as to comprehend only threats of criminal or tortious acts, and thus to exclude threats of breaches of contract. So again, built into his question in relation to contract is an acceptance that criminal acts would be sufficient. If we then look at page 1462 in the speech of Lord Devlin, 3/4 of the way down the page, paragraph beginning, this conclusion, while not directly in point, assists me, that's Bryn and Leatham, in my approach to the matter to be determined here. It is not, of course, disputed that if the act threatened is a crime, the threat is unlawful. And over the page, helpful in relation perhaps to the earlier parts that we were discussing, a paragraph beginning accordingly. Accordingly, I reached the conclusion that the respondent's second point fails, and on the facts of this case, the tort of intimidation was committed. I do not share the difficulties which the Lord Justices felt about the idea of admitting breach of contract into the tort of intimidation. Out of respect to them, I must state what those difficulties are and how, in my opinion, they can be satisfactorily resolved. I think that in one form or another, they all stem from the error that any cause of action by the third party, that is the appellant, must in some way be supplemental to or dependent upon a cause of action by BOAC. It's slightly confusing to the reference to the third party, because if one's thinking of this in terms of the unlawful means tort, he means the claimant. BOAC is the third party that has been intimidated in our formulation. But he then what matters is what he then says. Thus, it is said to be anomalous that on the facts of this case, the appellant should be able to sue the respondents when BOAC could not. So the argument is it's anomalous that the claimant victim can sue, but the third party that is intimidated can't. The best way of answering that is to grant that BOAC would not be able to sue, and to assert, as I shall seek to show, that there is nothing anomalous about it. So he is expressly embracing the three-party unlawful means analysis, which we say underpins the unlawful means tort. There was introduced into the argument a suggestion that BOAC could in fact have sued, because although there was no contractual breach of contract, one was threatened, and therefore there was an anticipatory breach. Against that, it was said that BOAC could not have sued for an anticipatory breach unless they first elected for a sin, which they never did. I dare say that's right, but I don't think it matters at all whether BOAC could sue or not. The two causes of action, BOAC's and the appellants, are in law quite independent. So that does make it clear in our submission that this analysis of the intimidation claim in that case is essentially the three-party unlawful means tort. And so it does provide a good ancestor to Lord Nichols' approach to the broader unlawfulness analysis in OBG and Allen. And then just to finish off this quickly, page 1465, again in the speech of Lord Devlin, more or less exactly in the middle of the page, it says, I find therefore nothing to differentiate a threat of a breach of contract from a threat of physical violence or any other illegal threat. So that, again, postulating a broad test of unlawfulness. And finally, page 1490, in the speech of Lord Pearce, again, right in the middle of the page, somewhere one must draw the line between pressure or coercion that may be permitted and that which may not. It is logical for the law to say that while a man may threaten to use all the means to which he is strictly entitled by law in order to encompass another's injury deliberately, yet he shall not threaten to use any means to which he is not so entitled. And again, that distinction between doing something that you're entitled to do and doing something that you're not entitled to do is the language of Lord Nichols in the broader unlawfulness test, embracing criminal conduct, breach of contract, and not merely being confined to actionable torts. And Lord Nichols expressly relied on Brooks and Barnard in his analysis. We didn't go to it, but between paras 149 and 155 in OBG and Allen, you'll see Lord Nichols relying on Brooks and Barnard. Just to refer again, I mentioned earlier the commentary by Deakin and Randall on the OBG and Allen decision. And they point out the line of arguments that everything said in OBG and Allen in relation to the tort, the unlawful means tort, is obiter. They also point out that Rooks and Barnard is cited in OBG and Allen and not overruled. And so they postulate that the dicta in Rooks and Barnard, recognizing the broad unlawfulness, could in fact be preferred to the obiter majority view in OBG and Allen, preferring the narrow unlawfulness test. One is left in a very odd position with, as I say, unanimous decision in Rooks and Barnard saying unlawfulness includes crime, and a possibly obiter majority view in OBG and Allen, which does not express itself as overruling Rooks and Barnard, but doesn't face up to the fact that what the majority is saying is inconsistent with Rooks and Barnard. So again, that's another illustration of why, with respect, OBG and Allen has indeed, I'm not belittling it, it has indeed achieved considerable clarity. But it has also done so at the expense of not facing up to some of the lack of clarity that remains. The other case, as I mentioned, Total Network, the Inland Revenue and Total Network, post-dates OBG and Allen. And in that case, as I imagine you are already aware, a claim was brought by the Inland Revenue against defendants in relation to a VAT carousel fraud. And the claim was brought on the basis of unlawful means conspiracy. Now, that threw up a number of legal questions. One was whether the Revenue, as a public authority, could bring a private law tort claim for unlawful means conspiracy. And the other was whether there was any relevant unlawfulness on the facts of the case. And that latter, the second question, required the court to face up to the question of what constitutes unlawfulness for the purposes of the unlawful means conspiracy. The answer to that, as I'm sure you're aware, the answer to that the court came up with was that essentially the broader Lord Nichols test from OBG and Allen is to be preferred in relation to the unlawful means conspiracy. I won't take you through it in the interest of time, but just to give you the relevant paragraphs, we have Lord Hope at paragraph 45, which is page 769, Lord Scott at paragraph 56, page 774, Lord Walker, paragraphs 93 to 95, at page 786, Lord Mance, page 116, paragraph 116, page 792, and Lord Neuberger, paragraph 227, at page 820. The other point, just before leaving it, which may be worth mentioning, is that Lord Walker also held that the interests protected by the tort of conspiracy are not restricted to trading activities. We get that in paragraph 100 at page 789. I don't think it's necessarily worth getting the case out for that purpose, because it is, I entirely accept, dealing with a separate tort, but it is striking that in paragraph 100, Lord Walker specifically says that the interests protected by the tort of unlawful means conspiracy are not confined to trading interests. And your lordships may feel that the direction of travel since OBG and Allen is not only against the narrower unlawfulness test adopted by Lord Hoffman, but is also against the dealing requirement, insofar as the dealing requirement would confine the unlawful means tort to trading relationships. And there is a certain paradox in that, because a certain amount of the noise that is generated around this whole issue and about economic torts generally is, it is said, that the common law is reticent about granting remedies in relation to purely economic loss, because it's a bit cautious about trespassing into the world of competitive trading. But the irony in this case is that the imposition of the dealing requirement actually has the paradoxical effect of necessarily confining the unlawful means tort to trading cases. Because there's got to be a trading, dealing, commercial relationship between the third party and the claimant in order for the tort to succeed, if that's what you decide. And it rules out other non-trading factual situations. So it would be a very perverse result to press into service the common law's supposed reluctance to provide remedies in relation to the competitive world, to press that principle into service, to confine this particular tort to precisely that area, but to deny it to factual situations which actually don't give rise to that concern at all. The other case we just wanted to mention is, in this context, is I've mentioned it already for a different purpose, is Appellants number 14, the case that goes on giving. The situation, as I think I mentioned there, was that the claimant bank had sued its own former manager for embezzlement. It had obtained a worldwide freezing order. That had been violated. The defendant absconded. And so the bank then sued Mr. Appellants and also his son-in-law, who was not a party to the original proceedings. And they were sued for an unlawful means conspiracy, for essentially combining in order to flout and thwart the worldwide freezing order. And so in that context, the question arose whether or not for the purpose of unlawful means conspiracy, the alleged contempt of court could constitute the necessary unlawfulness. And building on the dicta in Total Network, the Supreme Court in Appellants number 14 said, yes, that's good enough too. Again, in the interest of time, I won't take you through it, but I would commend you, sorry, I didn't give you the page reference. It starts, the actual report starts at page 519 in the bundle, and I would particularly invite you to, or simply to remind my Lord Lloyd Jones of his own words in paragraphs 10 to 15, page 536, and paragraphs 22 and 23, page 541. Because they also provide, as I say, I introduced it initially with the slightly different point about my learned friend's suggestion that the common law is very timid about allowing remedies, causes of action in relation to misconduct in litigation or in relation to administrative processes, because that, my learned friend would say, generates satellite litigation, cuts across existing regimes. And Appellants number 14 is a recent, very high illustration of exactly the counterpoint to that, which is that in an appropriate case, absolutely the court will allow a common law remedy in relation to abuse of the judicial process. So with that, very a brief introduction to the case law. All we really wanted to say is that what has happened clearly is that there is now a divergence between the law on unlawful means conspiracy and the law on the unlawful means tort as to what the necessary ingredient of unlawfulness actually is. That divergence highlights particularly one of the points made in the Sales Davis article, if I can call it that, both on a practical level and on a sort of structural level. The practical point that's made, and I'm just referring to page 2108 in the bundle, I don't ask for it to come up. The practical point is that because conspiracy works in the way that it does with this different test, the learned authors suggest that the search that a pleader will make for the claimant to find an arguable other conspirator and an agreement between the defendants can give the appearance, as the authors say, that a defendant's liability depends upon the imaginativeness of the claimant and his advisors in casting around to identify someone who might count as a co-conspirator. That is simply a sort of practical point as to how claimants will be seeking to fashion their cases. But the more important, in a sense, and principled point is made on the previous page, page 2107, which is that if one makes liability depend on the fact of a combination, that seems, as the learned authors say, it seems a distraction from what is far more important, namely the relationship between the defendant and claimant, arising from the deliberate choice of the defendant to use unlawful means to injure the claimant. It's page 2107 near the bottom. And in our submission, with greatest respect, that is an absolutely right insight. And it ties back in with why we say, as a matter of principle, the dealing requirement is so misconceived, because the dealing requirement constrains the scope of the unlawful means tort by reference to the relationship not between the wrongdoer and the wronged party, the real victim, but by reference to the relationship between the third party and the claimant. Because the dealing relationship asks, is there a trading relationship between those two? And the function of the unlawful means tort is to provide a remedy to the real victim. And the real victim is obviously the claimant. So what the important relationship is the relationship between the claimant and the defendant, not the relationship between the third party and the defendant. And the article suggests, and we respectfully say this provides a clear, principled and simple, in the best sense, a model for the tort, that the relationship is established between the perpetrators and the victim based on, as we understand it, the planned use by the defendant of unlawful means to injure the claimant. That provides a far more important element in justifying the contours of the tort. The question then is whether that particular model of the tort can accommodate the dealing requirement. And in our submission, it simply doesn't, and nor does Hazel Carty's approach. I would just invite you, because this is a sort of preemptive response to my learned friend's argument on this. It's in our submission, if we perhaps just get up page 2108, one sees the comment at the very bottom of 2108. In OBG, Lord Hoffman put forward the notion that the unlawful means tort is limited to cases of interference with the intermediary's freedom of economic activity, This is not inherently attractive and is contrived. The natives who had cannonballs fired at them in Tarleton and Magawley feared for their lives, not the interference with their freedom of economic activity, nor does it provide a viable point of distinction from unlawful means of conspiracy. It's inconsistent with the reasoning in Rooks and Barnard and a string of earlier authorities. It may be possible to argue that the tort of intimidation exists alongside ABG, such that Rooks and ABG operate in different spheres, but this is a result with which nobody concerned with doctrinal coherence in tort law can feel particularly happy. And so, similarly, Malone Friend suggests that the dealing requirement could be accommodated within Hazel Carty's analysis, and that, with respect, is not certainly how we read page 1892. Where you'll see right in the middle of page 1892, the learned author refers to Lord Hoffman's extra element. I recommend to you the whole of this and the next 2 pages, but you'll see that she refers to Lord Hoffman's extra element as a superfluous requirement by the time we get to page 1894. So our understanding both of the Sales-Davis model and the Carty proposal is that neither of them would accommodate the dealing requirement. And on principal grounds, it's not a matter of sort of textual analysis, it's on principal grounds because they proceed by reference to defining the tort, not by reference to the factual nature of the relations between the third party and the claimant, but by reference to a principled approach to the elements in the tort, which are driven by the court's perception of what the common law is trying to do here. And if you accept that what the common law is trying to do is to provide a remedy in relation to situations where unlawful conduct by any means is used with the intention of harming an identified claimant, then the nature of the harm that is caused, the nature of the relations between the third party and the claimant are an irrelevance to the structure of that tort. So that would be another way of achieving our much more modest ambition in getting rid of the dealing requirement. That's ground 3. Ground 4, I can deal with in the last 10 minutes relatively easily because it simply requires the court to look at a Canadian Supreme Court decision, AI Enterprises and Bram Enterprises. And the approach here is different from the Sales-Davis approach because it adopts the narrower unlawfulness test from OBG and Allen, and it hangs on to the intention requirement, but it expressly sheds the dealing requirement. And it's interesting with respect and an admirable piece of analysis, and you will, I think, enjoy and possibly benefit from studying it if you haven't already. The facts, just to give you the facts very, very briefly, there's a family-owned block of flats. Different family members hold interests through a number of corporate vehicles. The overwhelming majority of the family wants to sell, one doesn't. As it happens, that dissenter is managing the block of flats and uses his position to effectively frustrate the potential sale for 2 years. When ultimately the block of flats is sold, as it happens, to his corporate vehicle, and that does matter for the ultimate outcome of the appeal, when the block is finally sold, it's sold for considerably less than it would have been 2 years earlier if all the purchasers hadn't been put off. The claim was pleaded on a number of different grounds, including the unlawful means tort, and also breach of fiduciary duty because the holdings were through corporate entities. The claim at first instance succeeded on the basis of the unlawful means tort, but without OBG and Allen having been cited. When it got to the Court of Appeal in the decision in OBG and Allen was cited, the claim still succeeded because although the court felt that the dissenter had not used any unlawful means against the prospective purchasers who were the relevant third party for this purpose, no unlawful means had been used by the dissenter against the third party, but the Court of Appeal came up with the idea that there were principled exceptions to the requirement for unlawfulness, where somebody has resorted to self-help without any proper justification. So the matter then went up to the Supreme Court, and the Supreme Court said, no, you do need unlawfulness in the unlawful means tort, and there are no principled exceptions. And therefore the claim based on the unlawful means tort failed. But as it happens, the appeal was the dissenting family member's appeal was dismissed because the court considered that he had in fact been guilty of a breach of fiduciary duty, and the corporate vehicle through which he held his interest was liable for knowing assistance and knowing receipt. So that was the outcome ultimately. What matters for our purposes is that the Canadian Supreme Court essentially adopted a slightly simpler model of the unlawful means tort than OBG and Allen, essentially founding itself on the twin requirements that the defendant should have used unlawful means to strike at the claimant, and that the defendant should thereby have intended to cause loss. But it expressly, as I say, disavowed any dealing requirement, and it seems not to have required the instrumentality requirement as we conceive it. You may recall the instrumentality requirement as we understand it is that the defendant must have acted unlawfully as against the third party, and the third party's actions in relation to the claimant are the instrument for the injury. The way it's described in the AI Enterprises case appears to leave open the analysis that the unlawful act by the defendant may be the instrument of causing the injury rather than the actions of the third party being the instrument of the injury. But in any event, the one thing that is absolutely clear is that the dealing requirement was dispensed with. The basis of the analysis and the reason the court took the approach it did was that it built on what has been said in some of the case law we've already seen by regarding the rationale of the tort as being this, that the unlawful means tort, it says, does not involve the invention of some new species of wrong. What it does is simply to extend the range of potential claimants who can bring a claim for the wrong done to the third party. And the court coined the expression of a liability stretching concept, meaning that what is happening is not that a new cause of action is being given, so to speak, to the claimant, but that the claimant is being given a remedy in respect of the loss he or she suffers as a result of an actionable wrong done against the third party. So as I say, it stretches the liability of an actionable wrong, so it adopts the narrow Hoffman test of unlawfulness, and it stretches the liability in respect of that wrong to the true victim, essentially, because it is looking, as we suggest you should, at the question of the relationship between the defendant and the claimant, not the relationship between the third party of the claimant. Can we just then in the last 5 minutes look very quickly through that judgment? It starts in the bundle at page 822. And it may be convenient just to look at really at the beginning and the end. If we go to page 831, you'll see it's a court of 7. So all but 2, I think, of the Supreme Court sitting. If we look at page 831, para 4 identifies the issues. Before us, the main issue concerns the scope of liability for this tort, and in particular, what the unlawfulness requirement means. If the tort does not apply to these facts, we must also decide whether liability may be imposed on the basis of the breach of the fiduciary duty. And then helpfully it gives, paragraph 5 gives summary rulings. In summary, the issues and my conclusions are these. What is the scope of liability for the tort of causing loss by unlawful means? In light of the history and rationale of the tort, and taking into account where it fits in the broader scheme of modern tort liability, the tort should be kept within narrow bounds. It will be available in 3-party situations in which the defendant commits an unlawful act against a third party, and that act intentionally causes economic harm to the plaintiff. And that's why, as I say, it doesn't seem necessarily to be restricted to the instrumentality requirement as we have conceived it, where it's the third party's act that is the instrument of causing the loss. And then the next question, what sorts of conduct are considered unlawful for the purposes of this tort? Conduct is unlawful if it would be actionable by the third party, or would have been actionable if the third party had suffered loss as a result of it. Could I then just take you straight to paragraph 87 on page 864? And you'll see there, this is the point about the dealing requirement. In Lord Hoffman's reasons in ABG, he added a further requirement to the unlawful means tort, namely that the unlawful means employed must interfere with the third party's freedom to deal with the plaintiff. Lord Hoffman held that without such a limitation, there is a danger that it will provide a cause of action based on acts which are wrongful only in the irrelevant sense that a third party has a right to complain if he chooses to do so. This additional requirement has not been included in the formulation of the tort adopted by Canadian appellate decisions that otherwise approve of Lord Hoffman's approach to the unlawful means tort, although the point was not specifically at issue in those cases. Then, after citing them, respectfully, I do not find this additional requirement helpful in outlining the proper bounds of the unlawful means tort. This requirement is not supported either by the authorities or by the rationale for imposing liability. Whether the unlawful means interfere with the plaintiff's right to deal with the injured third party or with some other party, the fact that the defendant aims at the plaintiff provides a sufficient nexus between the unlawful means and the interests of the plaintiff to justify imposing liability. Rather than resort to this additional freedom to deal qualification, I prefer to limit the scope of the unlawful means tort through a narrow approach to both the unlawful means component, as discussed above, and the intention component, as discussed below. And he then goes on to discuss that the details of that don't matter for the purposes of this appeal, but we do commend that as an alternative approach to the answers in this appeal. So that is ground 4. You have our submissions. Can I just put myself on silent for a moment and check whether there is anything else that my team would wish me to say in opening before I hand over? And I'm glad to say at 3:30 as intended. That is the opening on behalf of the appellant.
Thank you very much, Mr. Crowe. Ms. Demetriou.
May it please the court, the key argument that my learned friend has made is that OBG and Allen and the cases which preceded OBG and Allen all just happen to be dealing cases on their facts, and that OBG did not purport to lay down a dealing requirement for cases with other fact patterns. And my learned friend also relies on obiter dicta from Allen and Flood, which suggested that whether there was dealing or not should not make a difference to whether or not there's a cause of action. But we say that it's important at the outset to recall that the present case is in fact a case about trade dealings. Why do I say that? Well, I say that because the appellant's complaint is that Servier's allegedly unlawful act directed at the European Patent Office and the English courts prevented the health authorities from trading with generic pharmaceutical companies which would have sold it the same drug more cheaply. So the appellant's claim doesn't fail because it's not about trading and not about an economic relationship. It fails because the economic relationship that they say was interfered with is a different one. It's an economic relationship which is disconnected from the unlawful act. In other words, the difficulty for the appellants is that the dealings between the health authorities and the generic companies don't assist it because they're not dealings with the third party who's the victim of the tort. And that is the reason why the appellants don't meet the test in OBG. It's because the dealings they say were disrupted are several steps away from the unlawful means they seek to invoke. And just to recall the steps in their argument, so the appellants allege that Servier, first of all, deceived the Patent Office and the High Court. Secondly, they say that this had the consequence of persuading the Patent Office and the High Court to grant the patent or grant the injunction in the case of the court. Thirdly, they say that those acts by the public authorities had the consequence of preventing particular generic manufacturers from entering the market. Fourthly, they say that that had the consequence of preventing a competitive process from arising which would have resulted in lower prices. And fifthly, they say that that had the further consequence of causing the health authorities to pay too much for perindopril. And what this serves to illuminate in my respectful submission is the function of the dealing requirement. The function of the dealing requirement, what it serves is to ensure a sufficiently close connection between the defendant's unlawful act and the claimant's loss. Now, Mr. Crowe said several times in argument this afternoon, well, the dealing requirement, all that does is establishes a relationship between the third party and the claimant. But in our submission, that's the wrong way to look at it. What it does is it establishes the link between the defendant's wrongdoing and the claimant's loss. So the difference between us, if I can encapsulate it in a nutshell, is that we both agree that instrumentality is required. What we say is that OBG laid down a requirement that instrumentality has to be effected through the mechanism of dealing. And what Mr. Crowe's case is, on the other hand, is that isn't required. All that's required by instrumentality is that the third party has to change the way it behaves as a result of the unlawful act. And then you have causation, that causes loss. And that really is the narrow point between us. But it's important in our submission to appreciate that what the dealing requirement does is connect the defendant's unlawful act with the loss suffered by the claimant. And it therefore, in doing that, prevents claims from loss which are remote from the unlawful act itself, or claims where the wrongful act is wrongful for a reason which has very little or no connection to the claimant at all. And we say that if the health authorities in this case have a claim in the circumstances which they allege, then so too must a wide range of other persons. And we think that the concession made by those representing the health authorities below was correctly made. That was discussed in the course of argument in response to Lord Hanlon's question. And we say that it's plain that if the health authorities have a claim in these circumstances, so too, for example, must private health insurers who are reimbursing parenteral purchases. And all of these different parties would have claims irrespective of whether they had any involvement in the proceedings in which Servier is alleged to have practiced a deceit, or any real connection with or interest in the matters to which the alleged deceit related. They may never have heard of parenteral or the crystalline forms of the drug, they may never have thought about whether the crystalline forms could have been produced using the processes disclosed in Servier's earlier patents. And yet they would be seeking compensation on the basis that what Servier told the European Patent Office and the High Court about those matters was untrue. And that's simply insufficient connection. And we say that on that approach, as I will come on to show you, the path would be open to all sorts of claims for pure economic loss suffered by persons who are far removed from the unlawful act itself. Far removed in two senses, far removed both in the sense of being several steps down the causal chain that ends in the loss, and also far removed in the sense of there being no logical connection between the nature of and the reasons for the unlawfulness on the one hand, and the loss suffered by the claimant on the other hand. And the courts, as this court, of course, will be intensely aware, have consistently recognised that claims for pure economic loss need to be tightly constrained, because, to make a very trite and obvious point, unlike cases of physical damage, which are constrained naturally by the laws of physics, the economic consequences of a particular act may be experienced by a large number of different persons, some far removed from the act itself. And just to return to a point that Mr. Crowe made in response to this submission, which we've made in our written case, he said, well, it's not open to us to invoke the reticence of the common law to permit recovery for pure economic loss, because the reason for that reticence is a reticence to intrude on competitive relationships. Yet this tort is all about competitive relationships. But that point is misplaced, because there are more than one rationales for the court's reticence to permit recovery for pure economic loss. And we're not focusing on the reticence of intruding in competitive relationships. The key point here, and a key reason why the courts are not keen to allow unconstrained recovery for pure economic loss, is that would allow indeterminate liability. And that is a matter which is of intense relevance in this case, because of the controlling function that we say that the dealing requirement fulfills. And what that requirement does is it's an administrable, easily applicable tool which enables the tort to be constrained within sensible limits, in the sense that it ties the loss claimed to the unlawful act. And of course, OBG, we've made the point in our written case, was a case in which the House of Lords heard 11 days of argument in relation to 3 different cases, and comprehensively considered the origins of the tort, its interactions with other economic torts, and all of the relevant case law and significant academic commentary. And the purpose of the judgment was plainly to rationalise this area of the law. Now, against that backdrop, our case in a nutshell, Servier's case in a nutshell, is as follows. First, we say that the Court of Appeal and Mr. Justice Roth were both right to find that the dealing requirement is clearly part of the ratio of OBG. So the majority in OBG were plainly saying it's an essential ingredient of the tort in all cases. And the reason for that is twofold. One is that it follows from the plain language of the judgments, and I'll come back to the judgments in OBG, to the speeches. But secondly, because it wasn't some afterthought or add-on. As I say, the members of the House of Lords in the majority conceived of the dealing requirement as fulfilling an important control function. We say that, so the first point we make is that the appellant's primary argument that OBG did not establish that the dealing requirement is an essential ingredient of the tort is wrong. The second point we make is that this court should not depart from OBG so as to eliminate the dealing requirement. And we say that the dealing requirement does not give rise to any injustice or anomaly, which is essentially the test that needs to be applied under the practice statement. What the appellants have said, and Mr. Crowe didn't dwell on this very much in his oral submissions today, but in writing, the injustice that they purportedly point to comprises a series of hypothetical examples, which they say would be examples worthy of satisfying the tort and worthy of relief being granted by the courts, but where the application of the dealing requirement would lead to the claim failing. And we say, in response to that broadly, that the unlawful means tort is, of course, just one tort among many that can provide for relief for the consequences of fraud in this type of context. And we've shown in our written case in response that in respect of each of the hypothetical examples that my learned friend has thought of, in fact, that there is another tort that provides relief. So it's important not to look at this tort in isolation. We say, thirdly, that in any event, none of the appellant's alternatives are satisfactory. Their primary case, as you've heard, is that OBG should be retained, so the model of the tort in OBG should be retained, save for the dealing requirement, which, as the appellants would have it, should be replaced with the weaker concept of instrumentality. And we say, and I'm going to come on to deal with this in due course, that that would result in there being insufficient constraints against remote claims. Essentially, it's the dealing requirement in conjunction with intention that ties the loss of the claimant, the unlawful act of the defendant. We say that the Canadian route, which is ground 4, suffers from the same problem. Indeed, it's worse because we agree with Mr. Crowe that the Canadian Supreme Court does not even require instrumentality. And so on the Canadian court's ruling, cases which most commentators and most courts have agree are correctly decided, such as Red Box, would be decided differently in our submission. And then finally, in relation to the article of Lord Sales and Professor Davies, we say that that article, as well as Professor Carty's commentary, is illuminating, if I may respectfully suggest, in this respect, which is that those learned authors, whilst urging on the courts the adoption of a wider concept of unlawful means, expressly recognised that that would have to be counterbalanced by a stricter conception of intention than the Sorrell and Smith intention, which is currently the law. And the difficulty, and so in my submission, in saying that, the learned authors were recognising that a tighter control mechanism would be necessary in those circumstances. And the difficulty that would consist in narrower intention. The difficulty for the appellants is that they have not pleaded any such narrower intention, and we say that nor could they plead such narrower intention in this case. And so, so for that reason, that approach does not assist them. Ultimately, the real question for this court is, in our submission, is there justification for overruling OBG? And again, in our submission, we say that the answer to that is no. The dealing requirement serves an important function, doesn't give rise to injustice or anomaly, and on the contrary, the appellants have proposed no satisfactory alternative. So I say that by way of introduction, and I'm proposing really to follow that structure in elaborating my submissions. And so I will start with the question of ratio of OBG. And I'd like to ask the court to pick up the OBG judgment again. And it starts at page 565. And just to recall that the appellant's argument, their essential argument, is that the only reason that the majority in OBG expressed themselves in terms of dealings was because that happened to be the fact pattern of the case that they were considering. They weren't laying down an essential ingredient of the tort. And we say that that argument is not sustainable, both because it's a distortion of the plain words of the judgment, and secondly, because it ignores the fact that the majority regarded the dealing requirement as serving the important function as a control mechanism of ensuring that the tort doesn't lead to claims for loss which are remote from the unlawful act. If we could please pick up the judgment from page 595. And paragraph 46. I'm coming back to Lord Lindley. You've seen this passage already, but I just want to make a couple of points on this passage. And you can see at paragraph 46 that here Lord Hoffmann is setting out the rationale of the tort. So he says the rationale of the tort was described by Lord Lindley. And this is his starting, this is Lord Hoffmann's starting point. This is what he says the tort is about. And so just pausing there and looking at the passage, you see the first few sentences: a person's liberty or right to deal with others is nugatory unless they're at liberty to deal with him if they choose to do so. Any interference with their liberty to deal with him affects him. If such interference is justifiable in point of law, he has no redress. Again, if such interference is wrongful, the only person who can sue in respect of it is, as a rule, the person immediately affected by it. Another who suffers by it has usually no redress. The damage to him is too remote. So pausing there, what Lord Lindley is saying is that this is a tort about interfering with dealings between the claimant and the third party. And he's also recognising the remoteness problem. So he's saying it's generally only the victim of an unlawful act who can sue, as loss suffered by others is generally too remote. But what he's saying in this passage,
strictly speaking, and it may matter when we come on to look at paragraph 51, strictly speaking, he's not saying there has to be an interference with dealing, but that there has to be an interference with the liberty or right to deal. So it's the third party's freedom to deal with the claimant, which is being interfered with.
Yes, yes, I accept that. I'm not seeking to make a narrower point than that. So we don't, but I'm grateful for you pointing that out, Lord Reed. But yes, we accept that entirely. And really, the point that I wish to make at this stage is that it can't be said that the dealing requirement is some kind of afterthought bolted on by Lord Hoffmann in paragraph 51, because his starting point here is that this is a tort about dealing. And he's also not saying that he was compelled by Quinn and Leatham to find that. So he's not saying that this was the ratio of Quinn and Leatham, and I'm not making that point either. What Lord Hoffmann is saying is that Lord Lindley was right, that this is the true rationale for the tort. So that's his starting point, and it's important because it does give context to paragraph 51, which we'll come on to now. So then you see passages which you've seen already, so I'm not going to go through them again, but 47 through to 50. Lord Hoffmann's there explaining some of the key elements of the tort. And then at paragraph 51, you can see that the purpose of that paragraph at the bottom...
I'm sorry, Mr. Demetrio, just before we move on to 51, yes. I would be assisted by hearing what you say about the opening sentence of paragraph 47, because there Lord Hoffmann seems to be drawing together both from what Lord Watson has said and what Lord Lindley said
Yes.
in
So,
a quite expansive way.
sorry, my lord.
Sorry, so I'm inviting your comments on that. Oh, did I? Did you hear my question? I was inviting you to make to explain why he expresses himself in that way.
Yes. So, my lord, my response to that would be that that you can see that at this stage, at paragraph 47, he's distilling the essence of the tort from what Lord Lindley says, but that doesn't detract from the fact that the rationale for the tort is about interference with dealing. So it all has to be seen in that context. That's Lord Lindley's starting point, and that's what Lord Hoffman is endorsing. And in that context, then these are the essential elements of the tort. And in my submission, that's the only way to make sense of paragraph 51, because when you come on to paragraph 51, this is at the end of a reasonably lengthy passage where he's elaborating on the essential elements of the tort. And paragraph 51 really is, in my submission, the paragraph which seeks to draw the threads together. So he says, you can see that from the wording, unlawful means therefore consists of acts intended to cause loss to the claimant by interfering with the freedom of the third party in a way which is unlawful as against that third party and which is intended to cause loss to the claimant. It does not, in my opinion, include acts which may be unlawful against a third party but which do not affect his freedom to deal with the claimant. And so that's completely consistent with reading 46 and 47 together. So he's saying this is the rationale for the tort. It's all about interfering with dealings because a person should be able to free to deal with a third party without unlawful constraint. That's the rationale for the tort. And then he draws out the essence of the tort, and then he comes back and draws all the threads together in paragraph 51. And then what you see, so just pausing on paragraph 51, we say that the Court of Appeal and Mr. Justice Roth were completely right to say that the natural meaning of those words is really unarguable in my submission, because he's plainly saying there, he's plainly laying down a requirement. And I don't think that a distinction can be drawn between the first part of the paragraph and the final sentence. In the whole paragraph, Lord Hoffman is drawing together the threads of the previous analysis and laying down what the essential ingredients of the tort are. And then you see at paragraphs 52 through...
Well, I don't believe that. I mean, in 51, the first sentence focuses on acts intended to cause loss to the claimant by interfering with the freedom of a third party in a way which is intended to cause loss to the claimant. So the focus is on the freedom of the third party, and it must be, I think, it must be a freedom in respect of potential or actual dealings with the third party if interference with it is capable of causing loss to the claimant.
My lord, we completely agree. So we say that is what it means, because one has to give meaning to, as you say, to interfering with the freedom of a third party, and you see what meaning that is in the last sentence. So it all must be read together.
Yeah.
And then you see, and this really does in our submission hammer home the point, paragraphs 52 through to 55, they're focusing on that requirement. And so what Lord Hoffman is illustrating in those paragraphs are he's going through cases which failed because the dealing requirement was not satisfied. So he doesn't just leave that final sentence of paragraph 51 hanging. He's then going on to put flesh on the bones, as it were, because he's then saying, well, look, thus, in RCA Corporation and Pollard, and he explains why in that case the dealing requirement was not satisfied. And he does the same in relation to Oren and Red Box Toy Factory. Now, it's true that one could explain those cases on the basis of a weaker concept of instrumentality. That's true, and that's what Lord Nichols does. But that is not, on a fair reading of Lord Hoffman's judgment, what he's doing. So, and if you see for example, focusing on the last sentence of paragraph 53, so he's saying there that he's just considered the RCA Corporation and Pollard case, which is the case about bootlegging of Elvis Presley records. And he says at 53, it's true that there was no allegation that the defendant intended to cause loss to the plaintiff, although given that the defendant was selling records in competition with the plaintiff, such an allegation would have been easy to make. But I do not think it would have made any difference. The wrongful act did not interfere with the estate's liberty of action in relation to the plaintiff. So that's precisely the point. He's applying the dealing requirement. Lord Lloyd-Jones.
Mr. Mitra, the same point had occurred to me when reading this for the first time, that it could be explained on a looser principle of instrumentality. But in your favour, I think it's also appropriate to draw attention to paragraph 52, about 6 lines down. The defendant was not interfering with the liberty of the Presley estate to perform the exclusive recording contract.
Yes, I'm very grateful. That's quite right. And really, the question here is not whether the case could have been decided on a looser, whether you could explain RCA and Pollard or Oren and Red Box, whether you could rationalise those as being correctly decided on a looser concept of instrumentality, because you plainly could. The question here is, what was Lord Hoffman doing? And what he was doing was he didn't have a looser concept of instrumentality at all. He was very clear that instrumentality meant the mechanism of interfering with dealings or potential dealings between the third party and the claimant. And we see that again at the last 2 sentences of paragraph 54. So this relates to the Red Box case, and it was a decision of Mr. Justice Jacob, as he then was. You see at the end of the paragraph, so this was a case in which, as you can see from the description, one of the claimants was the exclusive licensee of a registered design. The defendant sold articles which were alleged to have infringed that design right. But although the registered owner had a statutory right to sue for infringement, the question was whether the licensee could sue. And under statute, the registered licensee has no such right. So what they claimed was that the defendant was intentionally causing loss to the claimant by the unlawful means of infringing the rights of the registered owner. And then you see that Mr. Justice Jacob rejected the claim. The defendant was doing nothing which affected the relations between the owner and licensee. So again, a similar point to the one that Lord Lloyd-Jones just made. The exclusive license meant that the licensee was entitled to exploit the design and that the owner contracted not to authorise anyone else to do so. As Mr. Justice Jacob said, it is true that the exploitation of the licence may not have been so successful commercially by reason of the infringement, but the contractual relations and their performance remain completely unaffected. And those are words which are very similar to the words which were used to reject the unlawful means tort claim in the Douglas case, in the case of OK against Hello, which we'll come on to see. And they are focusing on the relation between the unlawful act affecting the relation between the third party and the claimant, and that being the mechanism through which the loss is caused. That's really the critical point. And again, we see that in the last sentence of paragraph 55 over the page on page 598. So this is relating to the Lonhro and Shell case. Again, the explanation for that decision is that Shell did not interfere with any third party's dealings with Lonhro, and even if it had done so, its acts were not wrongful in the sense of being actionable by such third party. And so just pausing there, far from being a throwaway remark, which is not meant to be treated as being an essential ingredient of the tort, what you then have is a careful exposition in these paragraphs of how that ingredient meant that these cases failed, and that's all that supports in my submission our case, which is that the dealing requirement is indeed a part of the ratio of the judgment and was intended to be an essential ingredient of the tort. So then we see.
Well, I wonder, Ms. Leach, I don't think you're going to complete your analysis of OBG this afternoon, are you?
No, I'm so sorry. I've just noticed the time. I'm not. Would this be a convenient moment just to break? If
you're able to pick up from this point tomorrow morning, then this would be a convenient point, I think.
I most certainly am.
Very well then. Well, in that case, we will look forward to hearing from you further at 10:30 tomorrow morning. The court will now adjourn. Thank you.